A recent 10th Circuit Court of Appeals case addressed the limits of the earmarking doctrine, and it's a good illustration of how courts deal with a specific fact pattern in the context of a preference case and earmarking. So what's earmarking? The fact pattern I'm talking about is pretty common and is as follows. A new creditor extends a loan to a debtor, but the proceeds of the loan are used to pay off an old creditor. There are a ton of variations to this fact pattern, but one common situation is that the new creditor directs the debtor specifically to only use the funds to pay the old creditor. And the new creditor pays the old creditor directly, so that the debtor never actually has physical possession of the funds. This all happens during the preference period, of course, so that the bankruptcy trustee will end up suing the old creditor for receiving a preferential payment right before the bankruptcy. The bankruptcy court faces the question at that time of whether the loan proceeds should be treated as property of the estate, property of the debtor, and whether there is a diminution of the bankruptcy estate when the debtor or the new creditor pays the old creditor. Is there less money in the estate to distribute to unsecured creditors? The earmarking doctrine is a court-fashioned, equitable safe harbor for the old creditor who's being paid during the preference period. Basically, the doctrine asserts that the debtor's estate is not diminished, since the debtor had no control over the funds used to pay the old creditor, and those funds could never have been divided up to pay unsecured creditors. The doctrine also postulates that what really happened was just the substitution of one creditor, the new creditor, for another creditor, the old creditor. So the same difference. Doesn't make any difference to the estate, really. This would also have no effect on the bankruptcy estate, arguably, since it would not create a new unsecured creditor, a brand new creditor, and so in that situation require that the debtor's estate be divided up by yet another creditor. So you have another creditor, and so less assets for everybody. In Colbert v. Littman, the fact pattern was as follows. The debtor's mother agreed to lend the debtor $21,672.65 with the proceeds to be used only to pay the debtor's law firm. So the debtor's mother insisted, I'm going to make the loan, but you can only use it to pay the debt owed to the law firm. The debtor executed a promissory note, and his mother sent the check directly to the law firm. Of course, this all happened during the preference period, or you wouldn't be reading about it, so the bankruptcy trustee sued the law firm for a preference. The bankruptcy court denied application of the earmarking doctrine and granted summary judgment for the trustee. The bankruptcy appellate panel affirmed. Both parties agreed that the only real issue was whether the transfer constituted a transfer of an interest of the debtor in property, which is one of the elements required in 547B. The 10th Circuit, when reviewing the matter, cited to its own case in 2008, Marshall, which set out a two-part test to determine whether the debtor has a legal or equitable interest in property. The dominion control test and the diminution of the estate test. These tests are pretty much what they sound like. The debtor, does the debtor have control over the funds? Did the transfer of the funds lessen the amount of money left for creditors? In the Marshall case, a debtor used a new credit card to pay off an old credit card. The trustee sued the old credit card since the payment was during the preference period. The Court of Appeals at that time, 2008, found that there was control, since the debtor voluntarily entered into a loan agreement with the new creditor and directed that the new creditor pay the old creditor. Also, the court found there was diminution of the estate, since the funds to pay the old credit card could have been used to pay creditors, since it was property of the estate. In that case, the court agreed that a preference did in fact occur, and the old creditor had to return the money to the bankruptcy estate. The 10th Circuit distinguished the fact pattern from the current fact pattern. The difference is that here, the debtor did not direct payments to the lawyers, basically the old creditor, but rather his mother insisted that the funds be used in that way as a condition of the loan. Here, the debtor had no power at all with respect to these funds. Also, since the money came straight from the debtor's mother to the law firm, the money would never have been available to pay creditors, so it did not constitute a transfer of estate, since it did not constitute estate property. It never would have been available. Anyway, the court reversed the bankruptcy court decision granting summary judgment to the trustee. The dissenting opinion argued that once the debtor executed the loan agreement, the proceeds of that loan should be considered property of the estate that the debtor could have done with whatever he wished. The majority opinion countered that the note merely represented an obligation by the debtor to pay money and not an obligation of his mother to make a loan. So it was not property of the estate. The dissent spent some time bashing the earmarking doctrine. Basically, the dissent pointed out that the earmarking doctrine was designed to protect the co-debtor of the debtor. It was originally an equitable protection of a co-debtor, so that funds paid by the co-debtor to a new creditor would not be clawed back, and thereby recreating the co-debtor's liability to that creditor. The dissent pointed out that the new creditor may well pressure the debtor into getting a new lender, so it gets cashed out prior to the bankruptcy. That would be exactly what the preference laws were designed to avoid. A creditor applying pressure and getting paid in full in comparison with other unsecured creditors who are not getting paid in full. The majority denied that it was ruling on the applicability of the earmarking doctrine, specifically denied that. The majority simply said, we're only ruling that the payment to the law firm was not property of the estate. That's all we need to rule. I think the takeaway here is that you really never know what a court is going to do. In the end, all decisions are incredibly fact-based. I cannot really blame the bankruptcy court for its ruling, since it seemed to be clearly following the precedent of Marshall in denying application of the earmarking doctrine. I agree with the dissent, and I find it hard to believe that in one case the proceeds of the loan were property of the estate, and in this case the proceeds were not property of the estate, simply because the lender didn't sign a promissory agreement. I think the moral of the story is, don't make bets on the outcome of cases. There's more uncertainty than the outcome of a poker hand.